Hi, this is Richard Chamberlain. Welcome back to the Protecting Your Family's Future podcast. This is episode number 111, and today we're going to be talking about why you should not give your house to your kids. So, I'm not saying that you should not leave your house to your kids in a will or a trust or in a beneficiary designation. What I'm saying is you should not give it to your kids, and there's a big difference there. A gift is something that you do during your lifetime. And people will sometimes uh, think about putting their kids on their house, on the title to their house, either for probate avoidance or for asset protection purposes. And it's a bad idea for any of those reasons. So if you give your house to your kids, either to have it avoid probate when you pass away or for asset protection purposes, either you give it to them or you add their name to the title so that you are a co-owner with your child. What you're doing is you're exposing your house to their risk of potential creditors. So if they have a creditor, then their creditors can attach their assets and execute judgment against their assets to satisfy the judgment that they have. And now, if you have added them to your home is in that list of assets that are now available to their creditors. So by either having your kids own your house or adding them to the title with you, you're subjecting the house to their potential risk of creditors. So you don't want to do that. You also don't want to give the house to the kids, especially for asset protection purposes. Some people will say, well, I'm just going to transfer the house to the kids and it won't be my house anymore. They can just have it and the asset will be protected at that point. But what you're doing there is you are setting your kids up for a potential significant capital gains tax when you pass away. So when you give an asset to a person during your lifetime, they receive your basis in the asset. Basis is essentially, what did you buy the asset for? So let's say you bought your house for $100,000 and it's now worth $200,000 and you give it to your children. Well, when they go to sell the house, they have a capital gain because they took your basis in that house of $100,000. They sold it for $200,000 and they have a $100,000 gain that they need to pay a capital gains tax on. If, on the other hand, you leave it to them in your will or trust or beneficiary designation, then when you pass away, they receive the asset. And under current law, the basis that they take in that asset, the house in this case, is the value on the date that you passed away. So their new basis is not the $100,000 that you had, but the $200,000 basis that is the current value. So when they go to sell the house, they don't have a capital gain, so they don't have to pay any capital gains tax. So there are a lot of different ways to handle a house and getting it to your kids, protecting it from your potential creditors, avoiding probate. And all of those ideas, all of those goals can be met without either giving the house to your kids now or adding them to the title. So those are two things you do not want to do. So don't give your house to your kids. Hope that's helpful for you today. If you have any questions, you can reach out to us. Our contact information is in the show notes, and we will see you again next week. Thanks.